So let's imagine that you have brought a personal injury case to trial, and the jury finds that the defendant is 50% at fault, and that you, as the plaintiff, are also 50% at fault. In many states, that means you will recover absolutely nothing. That's a system called comparative fault, and today I'm going to explain what that is and why you kind of need to be aware of that as you're bringing your personal injury case. So comparative fault is the idea that the jury can apportion fault or blame to the parties. And you can often have this come up in a slip and fall type of case where maybe the defendants didn't keep an area clean or safe and the plaintiff tripped on it, but maybe also the plaintiff maybe should have seen it coming, should have noticed it, wasn't paying attention. And so in that situation, the jury can apportion fault, some to the plaintiff, some to the defendant. And in many states, that apportionment of fault has to be more than 50% on the defendant, or else the plaintiff gets zero. And that's a system called modified comparative fault. And to understand why that is, we have to talk about a concept called causation. So causation is the idea that the plaintiff has to prove that the defendant's wrongful conduct caused an injury that would not have otherwise occurred. And so the states that say that if it's a tie, if it's 50-50 in fault between the plaintiff and the defendant, that means that the plaintiff really hasn't proved that the defendant's conduct caused the injury, because the plaintiff's own conduct was a tie, was exactly the same fault as the defendant. And so for that reason, the plaintiff bears the same responsibility and recovers nothing. There are some states that reject this idea because causation is instructed separately to the jury. And Kentucky, where I'm licensed, is one of these states. It has pure comparative fault. That means maybe the plaintiff is 75% responsible for his or her own injuries, and the defendant is only 25% responsible. All that means is the defendant is only 25% responsible for the damages. So if they award $100,000, then the defendant must pay $25,000, and the plaintiff simply doesn't recover the other $75,000 of damage because those damages were caused by the plaintiff himself or herself. Comparative fault also comes up as between defendants, where let's say you're in a car accident and you go to the hospital and the doctor at the hospital commits medical malpractice. So now you've got an injury sort of downstream from the car wreck, and that's really sort of the fault of the medical malpractice by the doctor. Now, at common law, it was the case that whoever caused the first injury was responsible for any foreseeable medical treatment and would be on the hook for everything. But with the institution of comparative fault, that's not the case anymore. So the person who causes the car wreck can say, well, I caused certain injuries, but those injuries were made worse by this medical malpractice, and they can blame the doctor for that. Now, that creates a very difficult situation for the plaintiff. Let's say you sue the driver who caused the accident, and then in his answer to your lawsuit, he says, I'm blaming the doctor that committed this medical malpractice. Technically, the defendant who's raising that defense has the burden of proof on it. He's got to prove that the doctor was negligent. But the problem for the plaintiff is if you go to trial just against the car wreck guy, he's going to be sitting there and talking about how, your injuries were also caused by medical malpractice. And you have what's called an empty chair problem. If you don't sue the doctor also, then the jury gets to hear about some other defendant possibly causing all your injuries, and that person is not there to answer that. And that can be a very effective strategy for the defense. So when you have a sort of multi-tortfeasor problem, you've got more than one defendant, you have to make a choice as a plaintiff's lawyer, about whether you take that seriously and bring that other party into the case, as you probably would in the example I'm giving of medical malpractice following a car accident. Or you can say, I don't really believe that this is meritorious, and I'm not going to complicate matters by bringing in someone who really doesn't have a lot of fault, because defendants do this all the time. They will raise the comparative fault of other parties. And that gets into a whole problem of you don't want the jury to apportion fault to a defendant at trial who's not in the lawsuit. This is a big way that you can potentially, even though you win a case, not recover as much as you should. Comparative fault also comes up in our negligent security cases where there is a criminal actor, for example, a shooting or an assault on a business property. And our argument is that the business should have known that it was a dangerous area. There'd been crimes in the neighborhood or in the parking lot or wherever, and they needed to have security. And because they didn't, our plaintiff got injured. They will assert the fault, the comparative fault of the criminal actor in situations like this. Some states don't allow that. They don't allow the comparison of fault between negligent conduct, the business's failure to have cameras or a security guard, and intentional conduct, the criminal actor's act of assault. But it's unclear in Tennessee, if that's still the law, and routinely they are making that comparison. And we've seen that happen. There was a very famous trial here involving Aaron Andrews, a celebrity sportscaster, who there was like a peeping Tom incident at a hotel. And the hotel was able to allege the comparative fault of the peeping Tom and, split that and have that the jury award a lot of money, but put a high percentage on the criminal actor, which effectively reduced the recovery for the plaintiff. So this is a very sort of technical doctrine, this thing called comparative fault, but you do need to know about it if you're thinking about bringing a lawsuit, especially in negligent security cases. If negligent security is an interesting topic to you, watch this next video.